my dames and gentlemen. Today I am going to explain the circumstances under which compulsory license can be granted by the Copyright Board. In fact, there are circumstances under which the owner of a particular creative work may refuse to allow other people to make use of the product which he has actually brought out. So in such of those circumstances where any person who refuses to allow the public to use the intellectual product, the Copyright Board can be approached by the aggrieved person, and he can make an application to the Copyright Board to grant license compulsorily to him to publish the work or to reproduce the work which has been rendered by the owner. In such of those cases, maybe the Copy Board would like to conduct an inquiry, and it will actually ensure that the person who has actually done the creative work will be remunerated with proper compensation, and the board will actually make an appeal to the owner to grant license to the person who wanted the work to be published or to be reproduced. So this is the way in which the Copy Board is extending a helping hand to such of those people who desire to make use of the creative work which has been done by the owner. And equally the owner also is benefited by adequate compensation. So this is the first circumstance under which a compulsory license may be granted in a way where there is appeasement both to the person who has produced the work and to the person who desires to make use of it. The next important circumstances under which license could be granted is in respect of sound recording already recorded. The person who wants to make use of this communication again may approach the Copyright Board to grant the license. On receipt of the complaint, the Copyright Board, as I said earlier with regard to the other cases of literature, even in the case of sound recording, the Copyright Board will inquire into the details and shall direct the owner of such copyright to grant license to the person who desired to have his work to be published or to be broadcast. The Copyright Board shall direct the person who desires a republication or rebroadcast of the work on consideration of compensation to the owner in such of those cases. The other circumstances which we have to find out the license which may be granted compulsorily is in the case of literature, music and arts. Now in such of those instances, according to section 32, which speaks about provisions regarding procedure to obtain license, explains that an application has got to be made to the Copyright Board. The application must be in the prescribed form, and the application must be accompanied by a challan evidencing payment of proper fee prescribed under the Act. And then, on consideration of the request, the Copyright Board will grant license compulsorily to the person who has made an application for publication or for reproduction. So, in such of those cases of literature, music and art, the owner has got a right to grant authority or to grant right for a period of 7 years. So, the initial period of 7 years, the owner alone has got a right. So, in such of those instances where any person wants to make use of those work, he has got to make an appeal to the copyright board. That is why it has been rightly said that a period of 7 years from the first publication of the work, see, any person can apply after the period of 7 years. But even before the period of 7 years, it could be granted, provided the copyright board feels satisfied that it is a fit case to be granted, license to be granted. If such a work also requires translation, or for the purpose of teaching the children, or for the purpose of teaching any scholar, and for the purpose of conducting any research, in these cases the application can be made within 3 years from the date of its publication. So, in the case of art and literature, it is 7 years normally, but in the case of translation or for the purpose of conducting research and which has got some educational value, then in such of those instances a period of 3 years has actually been prescribed. So here we must understand the circumstances under which Copyright Board is granting license to such of those people who desire the work to be reproduced. Inferences may be in the form of copying the publications or the work of an author of a copyright with the permission of the Copyright Board. Now, the next important segment about which we are going to speak is on infringement. What is meant by infringement of a right? What is infringement? In fact, two important conditions are prescribed for the purpose of proving infringement. The first condition stipulates that there must be substantial or objective similarity between the infringing work and the original copyright work. So, there must be substantial and objective reproduction of the same matter found in the original to have been copied in the infringing product, in the infringing material. So that is considered to be the first condition. The second condition stipulates that the main source of infringing copy should have been derived from the original copyright work. Supposing somebody has copied from the original copyright, from that copy, if any person copies down or extract the same material, then also it amounts to infringement. Infringement from a copy of the original work is also infringement. So, but the point stressed here is that it should be from the original. The source must be a derivation of the work from the original. Now, what is infringing copy? This has been analyzed in the case of Sulamangalam Jayalakshmi versus Mehta musicals. There has been a leading case where a copyright can be from the copy of the original and where there is a repetition of the same work, but it should be derived from the original. Infringing copy, any reproduction or act of plagiarism. What is plagiarism? As I have already explained, plagiarism is nothing but copying from one book or from one literary matter. Exactly, the copy that is actually being made is the exact repetition of the thing that is found in the original. This is what is known as plagiarism. A reproduction or act of plagiarism, taking and using others' thoughts or writing, or importing of any intellectual work of another in violation the provisions of the Copyright Act will constitute an infringing copy. So that is what is known as infringement. So but on the other hand, if you take any work from the original source with the permission of the Copyright Board, that will amount to license. So where you extract or where you actually cull out any sort of material from the original ditto exactly, that is what is known as plagiarism, and it is infringement. So this has got to be taken into consideration. Now, what are all those matters which are found as infringing copy? Reproduction of literary, dramatic, musical or artistic work otherwise than from the cinematographic film. Then the second point is reproduction of a copy of the cinematographic film. Third, recording by embodying the same sound through any means of devices. 4. Sound recording or visual recording pertaining to any program or performance over which the performer of broadcasting rights subsists. Section 2M. Under Section 51, even reproduction of literary, dramatic, musical or artistic work in the form of a cinematographic film is also regarded as an infringement. So, this is what is known as infringement. Infringement is nothing but reproduction of the original material which belongs to a person who has actually created it, or who has produced it out of his mental ability. So if once a person copies that work and tries to pass it on in the market under his own name, this is what is known as infringement. In fact, in torts also, we are coming across a particular term known as passing off crimes. So when you are actually passing off torts, civil liability, where you are just trying to pass on the goods which is marketed by a different person out of his creative ability, by actually putting it in your name and trying to market that particular product which has been invented by another. This is what is known as a tort, which comes under the label passing off negligence or passing off liability. So here this is considered to be a tort, where intentionally, knowing fully well that the work that has been done is by others, if you try to take that work and try to market it under your name, this is what is known as passing off. Like that, if any work that has been produced by another person out of his creative ability is copied by some other person, and who wants to market it by just introducing it to the public for earning money, then it is a case of infringement. See, wherever there is a commercial intention, a person who wants to make out money out of the work which has actually been done by other, and he wants to pass it on under his own name, this is what is known as infringement. So infringement is considered to be an offence under which the act will actually hold a person liable. It may go to the extent of say about 6 years or 50,000 rupees penalty can also be imposed, about which we will study later. Now, what acts will not amount to infringement of copyright? For example, if any person extracts the work from the original copy for the purpose of making use of it for any research purpose or for educating any other person with artistic aptitude or mentality, or if such original work is actually taken for scrutiny and analysis for the purpose of explaining it and for the purpose of bringing out the implications in that work, well, that will not amount to infringement. In fact, there is a leading case which you have got to make use of it here. That is the case of E.M. Forrester versus A.M. Parsuram. So that is a case where A.M. Parshuraman, who was actually running a tutorial college under the caption Minerva Tutorial College, and in that college he was actually publishing some work coming under English literature for the purpose of enabling the students to study it and pass their examination. So, in the course of his regular day-to-day work, he actually published some notes so that it may be easily understood by the students who have actually failed in the examinations. And with the help of these students' notes, they will be in a position to clear the subsequent examinations. So here he took a particular passage from E.M. Forrester's work, that is known as Passage to India, and he wrote a commentary on that work after extracting the original piece. Now this was objected to by the author E.M. Forrester, who filed a case against A.M. Parsuram. Now in that particular case, the court analyzed the entire facts and it came to the conclusion that there has been no infringement at all. In fact, the original piece of work has actually been analyzed and it has been explained exhaustively so as to enable the students to understand the passage and make effort to appear in the examination and pass in the examination. So, this work was considered to be only a work which has been intended for enabling the students to clear the examination. In fact, the judge has made an observation that sometimes the commentaries that are made on original work should not actually be misconstrued as infringement. He goes to the extent of saying that on account of commentaries, some of the work actually became very popular. In fact, William Hazlitt has actually commented upon Shakespeare's work, and Shakespeare's work has become more popular on account of the comments that have been given by William Hazlitt. So, about Shylock's character and all that. So, sometimes the commentaries that are actually made by a person with critical approach to the subject matter and exhaustive explanation which he has given makes the original becomes more popular and most interesting. So that is how one has got to view any sort of work that has been rendered by a person for the purpose of promoting education and all that. It should not be considered as infringement. So that is one thing which you have got to observe. The second circumstances under which a particular work should not be considered as infringement, that is the case where a work has actually been copied or extracted from the original for the purpose of explanation pertaining to any legal matters or with regard to any comments that are made by a person pertaining to literature on which any legal aspects are involved. So that is the second instance where it will not amount to infringement. The third circumstances under which a work will not be considered as an infringement, where the parliament or any proceedings before the legislature, if it warrants or if it calls for analysis of any literature, well, in that cases also, where for the purpose of discussion before the parliament, any literature may be analyzed and explained. So that will not amount to infringement. Then the next thing is, where a person who is in lawful possession of the computer program should not be considered as a person who has infringed the copyright. He may use it even for making backup copies as protection against a loss, destruction or damage to the original program. This should not be treated as infringement. Then reporting current events in a newspaper or similar periodicals or by a broadcast or cinematograph film by means of photography would not constitute infringement. Eastern Book Company versus Naveen Desai, it was held by the court that merely by correcting certain typographical or grammatical mistakes in raw source and by adding commas and full stops and enumerating paragraph numbers to a judgment will not make the work as original entitled for protection under the Copyright Act. So, these are the aspects which I got to bear in mind. Then any sort of abridgment, any sort of production of a digest for the purpose of making the professionals to understand thoroughly the case laws and the inner implications with regard to legal matters, when it is given in the form of notes, that will not consider to be an infringement of the original work. So that also you have got to take note of it. So these are all the matters. Not only that, when a particular original work has got to be reviewed for the purpose of making the public to become aware of that particular creative work, when we find some of the books are reviewed and the newspapers, leading newspapers, they give out the books which have been recently published and they give out the substance of those work. So that will not amount to infringement. On the other hand, it makes such of those works to become more popular and more marketable. So these are some of these matters which you should actually consider for the purpose of finding out whether there has been infringement or not. So it goes on saying, but one thing I would like to stress here is, when any work is actually copied from the original for the purpose of benefiting the public, say in a hall, in a big hall where the lectures are conducted, when a particular work is taken up for discussion and for commentaries and for the purpose of intellectual enjoyment of subtle analysis of the piece involved in that particular literature. So, well, that will not amount to infringement. So, there is but if any person wants to eke out livelihood on account of copying these things and wants to market it and makes use of his name and extracting the original without obtaining the license from the copyright board, well, this will amount to infringement. So, where there is a commercial motive to make money on account of marketing another man's work under his own name, well, that will amount to infringement of the original work. So, these are the things that you should take into account. Then, determination of the issue relating to copyright infringement. The court invariably is reluctant to occupy the position of an expert in order to decide whether there has been an infringement of copyright claimed by a party to the dispute. Court itself requires the help of an expert to find out whether there has been an infringement or not. What are the tests for infringement? Supposing somebody comes and gives a particular matter, namely the infringing copy, and wants you to say whether it is an infringement from the original copy. What is the test that you have got to apply? Layman's test. What is layman's test? A common man, if a copy which is alleged to have infringed the original right of a particular owner, and if it is given to a layman, what is his opinion? If he is able to point out the niceties and nuances in the work, and he is able to point out that in such and such aspects it resembles the original and it is nothing but a replica of the original, even by a common man, where these things are actually pointed out, this will amount to clear infringement. Because as a common man finds it, when similarities are found with regard to the original work and the copy, well, that is an infringement. That is what people say. Infringement of copyright has to be tested by visual observance of the drawing and the object in question. For the purpose of proving infringement of copyright, efficacy of different parts or the component parts and the style of the object, these are the things that are to be noticed. In fact, I have already explained to you in Kannaya versus Balraj, where the picture of Gandhiji is said to have been a copy that has been infringed from the original. So it was considered to be an infringed copy. Why? Because the various expressions and the muscle twitches and the folding on the towel which Gandhiji is wearing in the picture will amount to really an expression, and ideas cannot be infringed, but the expressions can be infringed. So that is why it has been said that the ideas are considered to be the framework and the expressions will amount to infringement. So enlargement of the edition work of law books from the student edition to professional edition will not amount to infringement. Bharat Law House versus Wadhwa and Company Limited. Any screenplay, story, drama or movie taken differently which are based on the true life of a person as reported in newspapers will not amount to infringement. Indian Express Newspaper Private Limited versus Dr. Jagan Mohan Mundra. There is another case. Publishing notes for the benefit of the students from out of the prescribed syllabus by the university is not an infringement. Ramesh Chaudhary versus Ali Muhammad Naushi. So, any reproduction exactly similar to the original work and any unauthorized broadcasting of any work, play or drama belonging to another person will amount to infringement. The concept infringement is equally applied with force with regard to imported copies. If any foreigner has produced a work and that work is being imported by any citizen in India, and if such copy, namely the imported copy, is once again infringed by actually copying it and by publishing it without the permission of the original foreign writer or the creator of that work, will amount to infringement. In such of those cases also, the copyright board can be approached, and the copyright board will function as a regular court to inquire into the details, and it will find out whether there has been infringement. Where it finds any sort of infringement, adequate remedy will be awarded to the person whose work has actually been imported and copied. So that is it. But one aspect has to be observed here. So far as the provisions applicable to the imported copy work should be applicable even in foreign country with regard to any matter that is imported from India. If any imported Indian copyright is protected by a foreign country, equally such of those copies imported from foreign countries will be actually protected in India. So it is more or less a reciprocal adjustment both by the importing country and by the exporting country. Well, if such of those infringed copies are resold or marketed if any money has been made and if the exact amount exceeds 10,000 rupees, the amount that is considered to be in excess of 10,000 rupees will be granted by way of compensation to the person who has actually written or produced that work originally. Then you have got copyright board. This copyright board is an autonomous body consisting not less than 2 members and not less than 14 members. The chairman of the copyright board shall be a person who is eligible to become a High Court judge or who is a High Court judge. So the copyright board contributes lot of help to the artisans, to the performers, and to the various publishers and original authors. So the copyright board has been constituted for the purpose of protection of artists and the persons who are producing some creative work. So this copyright board has got various activities. It helps a particular person who is considered to be a genius in producing creative work. This copyright board could be approached for the purpose of publication of his work. Secondly, the copyright board also will try to explore possibilities of directing the person to seek financial help from reliable resources. And thirdly, the copyright board will always inquire into the details of cases pertaining to infringement, and it will be able to set the record straight by conducting investigation and inquiries whether there has been infringement. And the copyright board also will enable a person to market his work, and it will also grant license where a owner refuses to grant permission to another to publish his work. In such of those cases where the book has become obsolete or the book is not at all available in the market, in such of those cases also the copyright board will explore possibilities to trace and find out the original copy, and it will actually, under its authority, will permit others to reproduce the original work and provide them in libraries so as to facilitate the public to have access to the original work. So these are all the various ways in which the copyright board is actually functioning. The society here, the copyright board, which is known as society, is granting licenses also on application forwarded from the owner of the copyright to such person or persons on collection of fees prescribed. So on the application of the owner, it can grant license to such of those persons as desired by the owner to be granted on receipt of consideration. Society will pay fees collected to the owner of the copyright after deducting the expenses it has incurred. Owner of the copyright can withdraw authorization granted to the society. So the society can enter into agreement. In fact, you must understand, copyright society is a larger body and copyright board is the controlling authority. Copyright, in order to elect the members of the board in the copyright body, a person must first of all become a member in the copyright society. When once he becomes a member, then these members are eligible to constitute a board which is intended for protecting the members of the society. Any non-member who is not, in other words, who is not a member in the copyright society cannot try to seek help from the copyright board. So in order to enjoy the privileges and concessions that are granted under the copyright society's supervision, one must be a member of the copyright society. Then these members actually constitute the board. So that you have got to understand. Now the next important segment is, what are the remedies that are granted for infringement? I will try to explain succinctly because the remedies are considered to be very elaborate. These remedies has got to be studied under the following heads. One is under civil law, what are the remedies that are granted? Second is under criminal law. Third is under the administrative procedures. Now, first let us take up civil law. Under civil law, as you said, the Copyright Board has got authority to inquire into the details, to conduct investigation and find out whether there has been an infringement or whether license could be granted to a person who applies for reproduction of the work and all that. So, it can summon any person as a civil court enjoys the privileges. It can actually summon an expert to find out whether there has been infringement in cases of infringement, and it can also get the opinion of an expert. So these are all the powers that are actually vested with the Copyright Board. So this Copyright Board has got not only powers to investigate pertaining to infringement, but it also has every right to settle any disputes that are brought before it for conciliation. So that is yet another segment where the Copyright Board, it is actually rendering human work, that is there. Then the Copyright Board also can find out the amount of compensation that are to be paid to the person who has created the work, where there has been any dispute with regard to compensation or where any damages are to be paid. The Copyright Board can interfere and grant such amount as compensation or damages as it may deem fit and proper in the circumstances of the case. So that is with regard. Then injunction. What is injunction? That is where any person is likely to commit infringement. The Copyright Board can actually grant injunction, a direction restraining that particular person who wants to infringe the copy of another person who has produced it, namely the original owner of the copyright. So these are all the circumstances under which Copyright Board is actually functioning. It can also grant specific performances. So these are all coming under the civil remedies as it is rendered by a civil court. Under criminal law also, prosecution can be conducted where any person has deliberately copied the work of original owner of the creative work, and it can impose punishment to an extent of 3 or 6 years with penalty to an extent of 50,000 rupees as actually stipulated under the Act. So, under a criminal procedure also, the Copyright Board functions, and it may actually punish and prosecute a person who has deliberately copied the work of another and committed the act of infringement. So that is under criminal law. Then you have got under administrative procedure, there is what is known as ante pillar, remedy of ante pillar, where it is found that a particular person has infringed the copies and he is actually multiplied the copies in order to enable him to market those copies and eke out his livelihood. In such of those cases, the Copyright Board can appoint proper inspectors to inspect such of those premises where these activities are carried on, to seize and confiscate the materials used for infringing the copies from the original. In such of those cases, they have got every right to have access to the spot or to the houses where the activity of infringement is actually taking place. So, in these cases, they have got to give adequate notice, and they have got to, if any female people or ladies are actually residing in a particular residence, adequate notice must be given, sufficient precaution must be taken so as to employ only female individuals to go and visit and inspect those places. These are the remedies that are granted as it is available under the criminal proceedings. Now, coming to the total period of duration of period up to which copyright is actually given has been analyzed, and it has been tabulated by me in a column. So you can actually make use of this column to understand the duration up to which a copyright is available. The nature of the work and the terms of copyright and relevant provision in the Copyright Act. So these are the three classifications under which the rights that are enjoyed is actually tabulated. For example, published literary, dramatic, musical and artistic work. This is available for a person. He can enjoy the copyright, any particular owner or produce the work, till his lifetime, and thereafter 60 years by his legal representatives. In the case of anonymous work means any person who has written the work whose name is not disclosed. And pseudonymous means any person who is not giving out his name, real name, but writes any sort of work under a different name, under a pseudonym, that is a false name. So he is also enjoying the copyright for 60 years from the beginning of the next calendar year after publication, if identity of the author is not disclosed. If identity of author is disclosed, his lifetime plus 60 years. Then posthumous work means any work that has been done, but the creator of the work, the person who has rendered that work, is no more. So for such of those piece of work, you see, 60 years from the beginning of the next calendar year after its first publication. And photographs, 60 years from the beginning of the next calendar year after its publication. Cinematograph film, 60 years from the beginning of the next calendar year after its publication. So these are all the periods that have been enumerated under the Act up to which a person who has produced the work will have enjoyment copyright. In fact, I have covered, not exhaustively, but for the purpose of enabling you to understand the salient features of Copyright Act. If you understand this much, that is more than enough for the purpose of analyzing the Act and understanding the niceties in it. Thank you very much.